Apologies, Your Honor. I'm ready.
All right, we can finally get this going. Only been a 30-minute delay, so it's not too bad. Let's pull up the docket. Ugh. Today we are here, Nathan Kookie, the Acquaviva Systems and Steel. As I do with any case, I don't look too much into it prior because I don't want to conflict myself with anything. And I listen to most of what you have to say in court, and then obviously in the ruling I go through every bit of detail that is provided to me. That being said, any opening motions before we get started?
Nothing from the
Oh,
plaintiff, Your Honor.
you're not gonna do the subpoena request motion?
I mean, I'll do it through my court trial.
Okay. I guess the defense did have a motion to dismiss. We have a motion to dismiss this case. On the grounds that it is legally baseless. There's no legislation in place for fair market valuation. Grounds that he's contractually not under any obligation. The defendant is under no obligation contractually either to provide a fair market valuation. So there's no legislation or contractual obligation. So that's why we're basically motioning for dismissal. The full motion is on the docket if you'd like to read it, or if you want me to read it out, I can.
Counsel, do you have any rebuttal to the motion?
Of course I do. There's a contract, Your Honor. It clearly states in Section 3, ownership stakes and board status. Execution of this agreement grants the founding investor 15% equity ownership stakes in the company. The founding investor is hereby granted official status of the advisor stakeholder of the founding utility board, entitling them to standard profit dividends proportional to the equity. Therefore, they have to provide financial books so he can know what he should be getting paid from his dividends that they've obviously told him that he gets in this contract.
Your Honor, profit dividends is not the same thing as a fair market valuations of his shares or how much his shares are worth.
Again, Your Honor, he is a stakeholder. He should be able to know what the company is doing, how it's being operated, as he is a owner with shares in the company.
Your
It's
Honor,
all in the contract.
Minor stakeholder, and also the contract. While the contract does admit that he does have a 15% equity ownership in the company, it does not stipulate in anywhere in the contract that he deserves a fair market valuation of what his shares are owed, and it doesn't even stipulate that the defendant here has to buy his shares at whatever value that he offers. This is the whole point of a negotiation of shares or value of shares, is that they can offer to buy it at X amount, and the one selling it can either accept or refuse.
Your Honor, it clearly is very simple business law. If you're an owner of any company, you have rights to the books. It doesn't matter if you're a 15% shareholder, it doesn't matter if you're a 1% shareholder. You have rights to know how well the company is doing with your investment. It is proper procedure of any business, Your Honor. This is what we're here for. I don't care if they don't want to buy him out. I just want my client to have access to the books so he can know how his investment is doing.
With respect, Your Honor, they usually stakeholders don't have access to the full books. What they have access to or would have access to are the public documents, which are available to anyone. So they'd have quarterly financial reviews, reports, profits, revenue. That's what they would have access to. However, what the plaintiff here is asking for is full access, full unequivocal access to the books, which we are we are wholly against it. It's not legislative and it's not contractual obligation.
Your Honor, it doesn't have to be legislative. It's business law. I understand that my friend
Go on,
over here on
Mitch.
the other
Go on,
side is
Mitch.
out of his depths with this one. At the end of the day, they initiated this engagement. She offered to buy him out. He got a lawyer. The lawyer asked, "Let me see the books to make sure this is a fair offer." They denied that. They stonewalled us. So this is why we're here today. I respectfully ask you to dismiss this dismissal and let's just go forward with this trial. I don't know why we're standing here arguing about this at this point.
I presented my arguments, Your Honor. It's up to you. I would defer to the court.
All right. Well, I'm looking at everything written down, and I was listening to the arguments provided. All right, gentlemen, here's what I'm gonna do. The motion itself is gonna be denied in part and granted in part. To the extent that the plaintiff seeks operational management, veto power, or direct oversight of business decisions, those claims are dismissed. Owning minority equity does not grant operational authority. However, as to the request to dismiss this whole case, that's denied. While the defense argues the plaintiff waived his rights, no contract nullifies the implied duty of good faith and fair dealing. Slashing a buyout offer from 51,000 down to 10,000 immediately following a request for financial verification raises a issue of bad faith valuation and shareholder oppression. Whether that price reduction was a legitimate business expense or bad faith a devaluation is a question and fact that cannot be decided on a motion to dismiss and must be heard at trial. So
Understood, Your Honor.
that is the ruling on the motion. We proceed. All right, plaintiff, your opening.
Thank you, Your Honor. So, as we've already pretty much established through our pretrial dismissal here, my plaintiff was removed from the business. He was hired previously. He then was offered a buyout by Miss Aqua over there of 51,000. He got a lawyer. I started reviewing things. I respectfully reached out to her asking, or to her lawyers that she did hire as well, for access to the books, which we were then weren't granted. We were just stonewalled. They then came to us with a secondary offer. I was like, okay, well, let's hear what the offer is. They said it was $10,000. I just kind of laughed that off. I'm like, you can't just go from 51,000 to 10,000. I don't know what you guys think this is, but this isn't how this usually works. They said that she started spending money on upgrades, other things. I don't know, because again, we don't have access to the books. We are now raising questions as to what is happening here. We've also went back into negotiations for the third time, and they brought it up to 20,000. Like, guys, we're not even like going back to the original offer. I don't know what you guys are trying to do here, but it's not going to strong arm my client here. At the end of the day, we just want access to the books, so my client can know that his investment is doing something, that the company is profiting, and he just wanted to help.
Why
He
is chat
honestly
rioting?
just wanted to be part of the company, Your Honor, and they just removed him flat out without giving him a chance to fully give his input. Again, that's all stated in the contract as well. While the contract is vague, and that is going to be the main argument of opposing counsel, that's not on my client. That is on the owner who got this contract drafted, and my client should not be punished for that. However, I encourage the courts to step in and maybe complete this contract and make it so it is full and proper. That's kind of the whole reason we're here today, Your Honor. Thank you.
Thank you, counsel. All right, defense.
Thank you, Your Honor. Honorable Judge, ladies and gentlemen of the court. Today, we bring towards you a suit, or actually, we don't bring it, sorry, the plaintiff today brings a suit today that claims that the defendant acted in bad faith. Well, the defense here will show evidence and testimony that will demonstrate that the plaintiff's claim is not a legitimate dispute. It is, in fact, a frivolous action brought in bad faith and motivated by malice. The defense will show that this lawsuit is not about recovering damage or obtaining justice or even just an innocent look at the books.
I hope to God she's
Instead,
not
It
texting
will
me.
show that it is a calculated attempt to tarnish the hard-earned reputation of my client and her company, a business that was built through hours of dedication, sacrifice, and hard work.
Luna.
The evidence will further establish that the plaintiff's true objective is to gain access to confidential business information while inflicting unnecessary financial and emotional harm upon the defendant. Furthermore, the evidence will go ahead and prove that the
I'm not
plaintiff
touching my
was not
phone, by the
removed from
way.
the company or stonewalled. Rather, he was suspended due to suspending pending further investigation, and he chose of his own accord to leave the company. It will also demonstrate that the shareholder agreement is clear, specific, and unambiguous. The legislation is also clear and unambiguous that as to the afforded rights to the plaintiff. At no point does the agreement require the defendant provide a fair market valuation of the plaintiff's shares, nor does any legislation within the state. Nevertheless, despite having no contractual obligation to do so, and despite the fact that they did not remove them from the business, however, he chose to leave willingly, the defendant extended an offer that was more than fair. The plaintiff declined that offer, and while he will likely argue that he did so because he did not reflect the fair market value, the evidence will show this was not his true motivation. At the conclusion of these proceedings, we respectfully ask the court to dismiss the plaintiff's claims in their entirety. We further request that the court award the defendant her legal costs in the amount of $40,000, together with $10,000 in damages for the emotional
this
distress
fucking
and
guy is
business
stupid.
disruption caused by these proceedings, including the injunction that has prevented her from expanding her business. Thank you.
Thank
Your
you.
Honor, I just want to clarify.
Yes, Mr. Mitch.
Is he countersuing us?
Well, he's
I don't
trying
know.
to, but he didn't file it, so.
Well, I mean,
Okay, thank you.
we could file it after this proceedings. We're just, I guess, take this as notice of countersuit, depending on how this goes.
Is he trying to intimidate my client now, Your Honor?
I wasn't even addressing your client. I was addressing yourself, Mr. Sandberg.
All right, gentlemen, there's no need for argument. Let's move forward. We're going into the main bit of the trial. This being a business trial, specific into corporate law, I know we haven't had very many of them. I do also see this trial as very important to the businesses in the state and shareholders in the state, and this ruling could affect a lot of things. So, that being said, I'm going to allow you to bring up your witnesses. The normal procedure for that, and then we might have evidence brought up that needs to be clarified to the courts by the end of it.
Okay, Your Honor.
All right, plaintiff, floor's yours.
I call Nathan Kookie to the stand.
I don't know business trial procedure. This side, to my right.
Over there, yeah.
All right, Mr. Cookie, if you could just raise your right hand for me, please. Do you swear, Nathan Cookie, to tell the truth and the whole truth and nothing but the truth, under the pains and penalties of perjury?
I do.
Thank you. Counsel, you may proceed.
Make sure,
Can
sure
he
you-
raise his
Shouting,
voice,
please.
sir?
Yeah, I raised it. We're good.
Also, if you could instruct the witness not to respond immediately to any questions, so that we give us a chance to object. If
is this your fucking like? I was about
One
to do that.
second. One
apologies,
second.
I was just all right. My bad.
Gentlemen, I don't know where this started. If an objection is put in, even if he's somewhat answered a question, I rule on that objection, and then depending on that ruling on the objection, I either throw out the answer and the question, or I don't. This whole 1 minute thing, We can do that. That's fine.
Oh, I didn't mean it. No, apologies.
Yeah.
I didn't mean that.
But I'm wholly capable of separating when an objection is made to remove a question or keep a question.
Understood, Your Honor.
Go ahead, counsel.
Thank you, Your Honor. Nathan, what was your status in the company?
Uh, I'm pretty sure I was a shareholder.
Okay.
It's not
How long
answering
ago,
correctly.
do you recall how long ago it was that you purchased these shares?
Like probably like a month and a half ago. Couple,
Okay.
you know.
At what point did you find yourself removed from the company?
Uh, about like 2-3 days after she wanted to buy me out.
So she wanted to buy you out.
Mm-hmm.
So she started the negotiations by offering a buyout.
Right.
Have you ever seen any from your stakeholder?
No.
Um, did you ever receive notice that you were suspended?
No.
Did you receive any notice that you were fired?
No.
So, from your understanding at this moment, you should still have a job there.
Would assume so. I'm a shareholder, technically.
And how much of a share do you have in that company?
15%.
And if she were to hire you back on, would you be willing to assist in the business and try to help any way you can?
I mean, that's the plan from the get-go. I feel like that's why you invest, right?
I would assume so. Um, what kind of hardship have you fallen under with this whole buyout that was offered?
Well, you know, I lost my job, so like I haven't really had a job. Um, so I've had to resort to other means to make ends meet, you know, pay pay bills, you know, keep my apartment. Um, and yeah, it's kind of even been like a struggle to eat. It's getting pretty expensive out there.
When you first made the purchase into this company, was there any like promises made to you?
Just that I would own 15% of her company and be active in the company.
So she just basically said you would have a job, you would get basically what the contract is
Objection, Your
stating.
Honor. This is leading.
Do you have a rebuttal, counsel?
I'm just trying to clarify what he was promised throughout the contract.
I'm gonna overrule then. Go ahead.
Yeah, basically just what my contract states.
So in the contract, do you recall any of the promises that was made in there?
The 15% and you know, obviously being able to work and stuff, and after that, no, not really. It's been a minute since I've looked at it.
Do you call anything about profit dividends?
Objection, Your Honor. That's leading.
That is a bit leading, counsel.
Can I ask him to
Sustained.
pull out his contract so he can recall what's written in there?
As the contract is listed in evidence, correct?
Correct.
Yes, then he can gladly use that.
You want to pull out the contract, and can you read number 3 of that contract?
Yeah. Um,
I am entitled to standard profit dividends, proportional to their equity.
Fantastic. And you've not received a penny of those, right?
No, you.
All right. Thank you. I have no further questions for him.
Thank you, counsel. All right. Cross.
One moment, Your Honor. Just can I have just 1 second?
Yeah.
All right, apologies, Your Honor. Mr. Cookie, how you doing?
Doing all right. How are you?
Not bad, not bad. So, Mr. Cookie, you mentioned during the direct examination that my client, the defendant, came to you with an offer of buyout, correct?
She didn't.
Why?
I don't know. She didn't really give me a reason. Her reason because of possum, which has
A
nothing
reason
to
because
do
of
with
what?
me.
Sorry.
Because of possum.
What's possum?
Another shareholder in the company who asked to be bought out. I never asked.
So she randomly just came to you one day and said, "Hey, I can buy you out."
Yeah, basically.
Okay. And you claim that she randomly woke up one morning and fired you for no reason.
Yeah, that's how it looked to me.
At no point did you ever quit yourself.
No,
Are you sure about that? I want to give you a moment to confirm that.
I never asked to quit. I never
I'm not
asked
saying
to
that
be
if you
fired.
asked to quit. I'm saying, did you remove yourself from the company?
No, I would not do that. No.
Mr. Cookie, my next move, when it's my turn, I will be calling up the defendant and another witness. They will
Your
both
Honor.
testify.
Objection. He is now actually threatening my client,
I haven't made a threat, Your Honor.
intimidating.
I haven't intimidated either. I'm just letting him know what's going to happen. No intimidation whatsoever.
Mr. Kenshi, I get what you're doing. I also understand his side of things. I'm gonna sustain.
All right.
Keep it to questioning.
Okay, I'll move on then. So walk me through it. You woke up one morning and you found yourself out of the company completely?
Yes.
You didn't
No,
and
you
did you
have to
attempt to speak
provide
to
with
the
other
defendant
means.
once you found yourself you were out of the company?
Well, this
Ugh.
was already by the time I was talking to a lawyer, so no.
So let me get this straight. You get fired randomly. You don't attempt to find out why.
Objection.
Objection.
Counts.
Testifying.
I'm just clarifying, Your Honor. I'm clarifying.
I understand you're
finished the question.
clarifying, but you are testifying about that, Kenshi.
Okay.
Sustained.
So let me clarify then. Why didn't you
You
try to
explain
find
some.
out why you were fired, allegedly?
Because we'd figure it out in court.
Alright, so what had happened here for chat?
Mr. Cookie, what was your
Mr.
response
Cookie
to the defendant
bought
when she came to you
15%
with a buyout
shares
of
in her
$51,000?
company. Then one day,
I'd like
allegedly,
to clarify as well. It was not 51.
he woke up
It was
and he was
50,
fired
but
and they wanted to
I
buy him
said
out. However, they gave a
basically
very
no, and then I'd think about it.
lackluster offer to buy him
So I thought
out
about it.
at 10k
And
without
now
proving
we're here.
that the 10k was equivalent to the 15% shares he held. And then they
Hold on,
claimed it
I'm
was
getting my information a bit mixed up here.
so
You
low
said it was
because they had
50,000,
to
not
pay for
51?
upgrades to the
It
company.
was 50,000.
Now, when
yes.
you enter buyout with a shareholder, you
On the court
cannot
docket, the defendant
devaluate the
your-
company by going and
Sorry,
buying
I'm just
stuff.
clarifying.
It might
The
have just been a
counsel.
mistake on my part.
Okay, I'm just
Clerical
trying to
issue.
clarify. No worries. All right. Well, I mean, we'll stick to the 50,000 then. If that's the so okay. So she came to you with 50,000. You said no. You'll think about it. Why did you then go to a lawyer?
I didn't feel it was fair.
How much did you initially invest?
Objection. Scope.
Sustained.
All right. That's fine. I can bring that up later. In your contract, were you forced to sign this contract?
No.
That is within scope, that's fine.
Did you? Okay. Actually, that's fine. That's been answered. All right. Yeah. No further questions. Actually, sorry. I do have one more question. Although, one more question. Sorry. You mentioned that you woke up without a job, correct?
hmm
So you weren't employed anywhere else at all at this time?
No.
Relevance?
Your Honor, he made the claim that he, because of his quote unquote loss of this job, that he was unable to, or had to find different jobs, odd jobs to get by. So I'm just clarifying to see if he was indeed employed anywhere else or not.
At the time of being
wait,
fired, no.
wait.
Sorry.
I'm gonna overrule. That is something he brought up.
At the time, no.
Yep. Okay, no further questions.
All right, you want to do redirect counsel?
No, I'm good.
All right,
You don't
Mr.
have to
Cookie, you may
there.
step down. I do believe you are also marked for recall, so just be aware.
Okay.
All right, plaintiff. Do you have any other witnesses?
No, Your Honor, I just want to again just bring your attention to a couple things that's within this whole case right now.
Yes, you can highlight specific points of evidence to me.
Perfect. So it clearly states in the contract he is he has an ownership of the company of 15%. Ownership usually comes with, being able to see the books, regardless of how much minority or majority of the company that you
All
own.
right. 1 second, Mitch. 1 second. You can only
Sure.
point me towards evidence. You
Okay.
cannot go into detail of it, so point me to where you want me to look when I'm deliberating
Sure.
later on.
Again, just the contract that was signed.
Mm-hmm.
And that's really the only evidence. I just the contract, Your Honor. That's really what we're here for.
All right, understood. Thank you, counsel. All right, that being said, we're pushing it over to the defense in this case. Kenshi, you may call up
Your
your
Honor.
witnesses.
Defense calls Aqua to the stand.
Good day, Miss Aqua. How you doing?
Hi.
If you would mind, be so kind as to raise your right hand for me. Do you swear to tell the truth, the whole truth, and nothing but the truth today under the pains and penalties of perjury?
Yes, Your Honor.
Thank you. All right, counsel, you may proceed.
Thank you. Aqua, I just have a few questions. Do you recall when Mr. Cookie was sold his shares?
Yeah, Penny, that guy was pretty sus
Sold
to
his
me.
shares?
As in when he bought shares into the company, invested into the company?
I would say like it was like around early June.
And how many shares was he given?
150.
How much did he pay for that?
$6,000.
Was there any point, any agreement between the two of you that he would have access to financial records of the company?
No.
Okay. What was the circumstances behind Mr. Cookie's suspension? Hello?
Sorry.
Objection, non-responsive.
Aqua, did you hear my
I'm
question?
gonna have to
Yeah,
sustain
sorry. So basically what happened was he made like an unauthorized call to the DOJ rather than like going through rather than allowing me to get counsel at least, and then like move from there if we like had questions about something.
Sorry, just to clarify, are you saying that there was an issue and he, instead of retaining counsel, he made a call that wasn't authorized by yourself?
Yes.
And did you attempt? Was this a big issue at the time?
Objection. Vague answers.
I'm gonna
So
have
he
to
was-
sustain counsel.
How is that vague, Your Honor?
It has been very vague answers.
Okay, could you elaborate? Could I ask her to elaborate then on those?
Yes, go ahead.
Okay, yeah. If you could elaborate on the suspension. So what did Mr. Cookie try to get advice on, for example, that he wasn't authorized to?
So for some reason he kept on hyper fixating on this like one raffle that was had in the city. We didn't have anything to do with organizing the raffle or running it. We just purchased tickets. And this like raffle like was already like facing a lot of heavy public scrutiny. And as CEO, like my duty is to protect my company's reputation and distance us from like these sort of controversies. So I guess instead of like exercising the same discretion, he just like recklessly like called the head of DOJ to ask like this like very like pointed question that I was kind of like warning him like why are you asking this? We could just like get like lawyers or something.
And when that happened, what did he do? What was his response?
He just like continued with it, and it was at that point when I deemed him to be like a liability, basically not really he was like basically going against the company's interests.
So you were worried about your company's reputational
Mhm.
damages. Okay. So you heard the Mr. Cookie, the plaintiff, testify earlier that you came to him with evaluation prior to quote unquote firing him.
Mhm.
Could you elaborate on that for us?
Yeah, so this was like right after we had like he had did that thing called the DOJ. We both have access to the app. He could see like the buyout price for the company. It wasn't like I was trying to shield it from him or something. Like he could see like it was a share to share, like whatever fair value was.
Right.
Like, yeah. So that's like what I offered him.
This is painful, Kat. This
So
is very painful.
you offered him a fair market value based on what the buyout was. and
Kenshi is
he could see
trying,
that, is
but
what you're
she's
saying.
just like,
Yes.
So at the time, there was really no need to retain counsel to check for a fair market because you could see that.
I'm not corrupt. She's
No.
just
Okay. Was his quote
skirting
unquote,
around
I'm gonna say
answers
dismissal
for
because
no reason.
actually I'm not going to say. I'm going to ask you. Did you dismiss him from the company?
No.
What happened?
After this incident, I really felt like I lost trust in him, so I put him on a leave of absence.
And did he leave the company on his own accord?
Yes.
What did he say to you when you offered him the $50,000 for his shares?
Why are you trying to fuck me over? It's not about the money. Why are you trying to fuck me over? I'm not possum.
It's not about the money. Okay. What did you have to do once he retained legal counsel?
I had to, like, get my own counsel, basically.
Mm-hmm. How much did that cost you?
It's cost me $100,000.
And how has that affected you emotionally?
It's been very stressful. I'm sure like a lot of my employees and the people that I care about, they've like noticed like a change in me and my demeanor. I've been like very worried about this.
How is this whole court case and
that's
the
the
injunction
problem,
that was filed
Shoto.
because of this?
People
How has
would
that affected
call
your
Mercy
ability
for
to
advice, and they would
progress as a
call
business?
Hank.
Very
Where
much like
They
a
shouldn't.
lot of the plans that we had
All that needs to
are-
happen is you call a lawyer.
been-
That's it.
like postponed like
That's where it
indefinitely,
stops.
basically.
We, as the executive,
Okay.
shouldn't be getting involved in a lot of this stuff.
I believe I have no further questions, Your Honor.
Thank you. Plaintiff, go ahead.
Thank you, Your Honor. Miss Aqua, you just testified that you retaliatorily removed, suspended, LOA him because he went to the head of bar, correct?
Objection, Your Honor. Misstatement of facts.
Your Honor, that's literally what she said. He went to the head of bar and she put him on an LOA.
All right, I'm
She
gonna,
also
I'm
said that-
gonna. Can she? I'm gonna overrule because she did state that he went against the company's interest by going to the hands of the DOJ.
With
at the
respect, Your Honor,
time.
she did testify continually saying that after they had spoken, he had continued to do that regardless of what she said. It wasn't just the fact that he went to the head of the DOJ.
And respectfully, I've overruled your objection. Go ahead, Mitch.
Again, Miss Aqua, did you not just testify that you put him on an LOA because he went to the head of the bar?
Yes.
Did you notify him that he was going on a suspension?
I sent a text message.
Do you have proof of that text message?
Yeah, going after that 100k. Yeah,
Yes.
100 fucking k.
Can you read it
man.
out for the
For what?
courts?
So it says, I've realized we have fundamentally different expectations about confidentiality, discretion, and how A.S.S should be run. After seeing your most recent text message, I no longer have the level of trust that's necessary for us to continue as business partners.
So that's you firing him then?
Objection,
No.
Your Honor. That's misstatement of facts.
What you read to me, it sounds like it's not a LOA or a suspension. It is basically we're cutting ties.
Shut up. I'm gonna
No.
overrule,
That is
so she can answer.
So that's not you firing him.
No.
Do you have any proof that he went to the head of the DOJ?
Yes.
What proof do you have of that?
I was in the car when he called her on the phone.
What did he say on the phone to her? And who's her? Just clarifying.
Mercy Schilling.
So you're saying he called Mercy Schilling while you were in the car to inform about something that you guys were doing within the business?
No.
Still no proof of this. She just
I'm
said she has
confused.
proof.
How did you hear this?
Brother, both these people are
I
fucking
was sitting
idiots.
in the car
Hello.
with them.
I think the question's a bit confusing.
Or when he called Mercy Schilling to notify her about your business. That's what you're testifying to?
No.
I'm confused.
She's a I'm confused as well.
What did he call Miss Schilling about then?
As I said, like, so how the raffle has been under scrutiny, so whether it was a scam or not. He was asking certain questions about whether the raffle was rigged, what would constitute fraud.
So what does that have anything to do with your business and the raffle that was done?
We purchased tickets.
Okay. What I'm still confused how him calling the head of the DOJ for a raffle has anything to do with your business.
I already explained a bit earlier, why I'm
So
concerned
this
about
guy
the business's
called
reputation.
the head of bar to
Your
ask
Honor, I have a
legal
motion to
question.
strike her testimony from the records.
On what grounds, counsel?
She's being very vague and not going into any details here. She's skirting a lot of the questions.
With all due respect, why would that constitute a striking? Surely that you
Because
just
I
need to
think
answer.
she's
ask the right
perjuring
questions.
herself.
All
I
right.
see no evidence of her perjuring herself, Your Honor. The high allegation.
All right, gentlemen. Counsel, I'm gonna deny the motion for now.
Okay.
I'm putting weight on the fact that I have perceived some vagueness in the answering. So do be aware that I'm taking record of how things are being answered and the way people are
Do
responding to questions.
you and the mayor have any kind of relationship?
What the
Objection,
fuck? That's the
scope,
mayor's.
relevance.
This has everything to do with the raffle, Your Honor. They brought it in.
No one ever mentioned the mayor or a relationship with the
It was
mayor.
his
or-
raffle.
We didn't even establish that in direct, Your Honor.
All right. I'm gonna have to sustain because the fact that the mayor was involved in this raffle was never brought into this court.
Can I just have one more rebut to that?
You can, but I've already sustained counsel.
Okay. Okay. Whose raffle was it?
Objections. Scope.
Again.
No,
I'm
that's
just-
that's overruled because you brought the raffle into scope, counsel.
Okay, I'll object to relevance then. What's the ownership of the raffle got to do with
because
this?
my client was suspended from the business because he called about a raffle to the DOJ. That is very relevant.
Again, I'm overruling. Answer the question.
What was
does
the question?
Okay, Dave.
Who
So
ran the raffle?
all this started because of the raffle, right? And because
The
he got
mayor?
concerned they could
Can you
get
state
into
his
legal
name for
shit,
the record?
he called the DOJ and told them some shit. Then
Mayor
she
Christine?
found out about it and she fired him because of it.
And I have to ask, why did it matter to you that my client was calling the head of the DOJ about the raffle and the fraud?
The mayor's not relevant. I'm not taking anything of the mayor into account.
It was under a lot of scrutiny.
What does that have anything to do with your business?
We purchased tickets in the raffle, like a large amount, like a lot of other businesses did.
Okay. I'm still not connecting the dots here at all. Miss Aqua, when it comes to the raffle and you buying tickets and him, wondering about fraud, why did it matter? He's just being a citizen that's wanting to make sure things were on the up and up.
Mitch is very good at gaslighting people, by the way.
I don't recall.
I have no further questions, Your Honor. This is, yeah. We're
Uh,
done with this questioning.
Any redirect, counsel?
Yes, Your Honor. I'll just have one question on redirect. I think this might help clarify what this has to do, the whole raffle business, and so you said in your direct examination,
She is dropping the ball on this.
and I believe you also mentioned it during cross that the reason was
Exactly, Shodo.
that there was an allusion to
And
the
because
fraud
my
being
business
done and that the
partner,
business was
partner kid,
involved.
because of the legality,
Is that
I
correct?
fired
Aqua?
him.
Yes.
Okay,
That's
so you
what this
so
is.
just to clarify, you were worried that there might be some reputational damage being done with Cookie,
And then they
asking
offered him a
unnecessary questions
51K
around fraud being
buyout
done,
and
seeing
dropped
that
it to
your business
10,000.
brought the tickets.
Yes.
No further questions.
Well, firing, suspending doesn't really
Your Honor, I
matter.
would like to put a motion of any call between Mercy Schilling and my client is called as hearsay.
Your Honor, she was sat in the car with him.
All right, I will only take into account what she has directly testified to hearing herself, and nothing that could be construed as what was said back to, or things she was not able to hear herself.
Thank you, Your Honor.
All right, you may step down, Aqua. All right, Kenshi, your next witness.
Jesse King, Your Honor. The defense calls Jesse. Sorry, Jesse.
Who's
Did I
Jesse
get
King,
that
Your
right?
Honor?
Jesse Quinn. Quinn. Sorry, Quinn.
I don't know who this is.
Is this listed as a
witness.
witness? Yeah, they have been listed
He's
as a
not a
witness,
witness.
counsel.
Okay. My apologies. I didn't see him on there.
All good. I thought I
All
made a
right.
mistake there.
Mr. Quinn, if you could raise your right hand for me.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
Yes, sir.
Thank you. The witness is sworn in. Go ahead, counsel.
Thank you. Mr. Quinn, if you could just state for the record your full name and your role at this business.
My name is Jesse Quinn. I am a project manager, part of the company. I assist in many regards with the management of the company. And
I've not leaned either way yet,
Thank you,
Shoto.
Mr.
I'm
Quinn.
listening
Were you
to what they're
aware
saying.
of the situation between Aqua and the plaintiff?
Yes, I am. I
How
was
much?
aware.
What's the extent of your knowledge to this?
Objection vague.
I can reword. I'm just trying to
Yes,
establish how
sustained
much he knows
reword,
about
counsel.
this. Okay.
That's
Were you
Crocs.
present in a lot of the dealings between Mr. Cookie or the plaintiff and the defendant?
Yes, I was.
And what was your capacity? Were you still project manager at the time?
Yes, I was.
Okay.
The entirety of the time.
Perfect. Could you, I'm gonna say, were you present during the negotiation between the defendant and the plaintiff for the original negotiation for the shares?
The buyout or just
Yeah,
the
the
buyment of
buyout.
the shares?
The buyout.
The original one I was, yeah.
Okay. Do you recall how much was offered to the plaintiff?
50K.
And what was his response?
He did not want to accept it.
Do you
Is
remember
that
why? Do you recall
Coyote?
why he
That,
did
I
not
don't
accept
think
it?
that's Coyote.
Yes, he
Objection relevance.
This is highly relevant, Your Honor. It speaks to the whole reason why he would hire lawyers when his claim was that he wasn't let go, and his claim was that he couldn't. He didn't know if it was a fair market valuation. He had access to the ventures app we've established, so he could see that what each share was. We're trying to understand what his mental state of mind was and why he brought this lawsuit forward.
All right. I'll overrule for now.
Do you remember what his response was?
Objection hearsay.
He was there in the room.
He hasn't been called back up there.
I will remind the court that I asked Mr. Cookie a few times, and you also almost added to intimidation while I tried to make sure that he understood the weight of his words, why he rejected the offer. He had plenty of time to explain why he rejected the offer.
All right, but that doesn't. So the objection is hearsay. Kenshi, you've not established very well that he was present there, so I'm gonna
No,
sustain for
I
now.
asked him if he was there. He said he was. I can ask again if that would help.
Yes.
All right. Mr. Quinn, were you present during the negotiation of the
Jesse.
original? Sorry, Jesse, were you present during the negotiation between the plaintiff and the defendant, the original one?
the original one, yes.
No,
Okay.
Penny.
So do you remember how much was offered?
50,000.
Do you remember what the plaintiff said?
He did not care about the money. He didn't care about what was happening with the company. He cared about being with Aqua, and that's why he wanted to stay in the company.
Okay.
She even
So
told
we've
him
got
about
a
dividends and
little
such.
herb
He
circle chat.
refused the entire
He
time.
didn't want the money.
He
He just
just wanted to be
wanted
a part of the company with her.
Understood.
This just got juicy. Scrux, he was offered 50,
Were
then
you
they
aware
dropped it
of
to 10.
Mr. Cookie's employment elsewhere?
Now the real
which
story
point?
comes out.
Which time?
During his quote unquote termination. Alleged
Objection
termination.
leading.
Sustained.
Okay. Do you know if at any point Mr. Cookie was employed anywhere else?
Yes.
Objection. Facts not in evidence.
We're establishing
I like
facts
this guy.
now through the questions. He claimed, I asked him in cross-examination,
All right.
in his statement, he claimed he wasn't.
All right. I'm going to overrule for now. Answer the question.
Do you mind repeating the question?
Sorry, the question was, were you aware or are you aware that he was employed at the time anywhere else or elsewhere?
Yes.
Do you remember where?
He worked at multiple different places. He was an investor in multiple different places also.
Okay.
Yeah, but just because you invest somewhere doesn't mean you work
Were
there.
you aware of the circumstances
Actually, Your
around his
Honor,
termination?
objection, vague answer, non-responsive.
I'm gonna
you want him
have
to
to
give exact-
sustain. Yes, he
Do you
has
remember
to be exact.
okay. Do you remember exactly what companies he was invested in?
To my knowledge, as he stated, this question did come up when we've been talking. He stated in front of me that he was investor in 5 different companies. I'm fully aware that he is an investor in a food place also at the time.
Objection,
Which
non-responsive.
I'm saying what the place was.
He's
was
getting
about it.
to it.
I'm gonna overrule for now. Finish answering the question.
One being Hex. Hex, I think that it's called Hex.
Mhm.
From our which I am also an investor of, with Nathan.
Okay.
That's
I
not
believe-
relevant though.
Oh yeah, I had another question. Were you
His-
aware of the circumstances surrounding Mr. Cookie's
His
quote-unquote
investments
suspension
has
slash
nothing to
termination?
do with did he work
Yes.
somewhere.
Could you elaborate on that for us?
Fucking stupid.
Um,
Can she? Please.
There's throughout the whole time he
Investments
was part of the
don't
company.
mean
There's
shit.
been multiple different times where it's been issues which come to question his shareholder position as such. At one point, he was employed at a different utility company, which was resolved at one point. He at the time was called no, sorry, let me take that back. It was discussed that he called the DOJ and multiple different individuals about how Aqua's company was alleged to have involvement in the raffle.
What
Even
kind
though
of involvement?
she bought tickets, but he was implying that we had a further involvement in the lottery itself when we're just a company buying tickets, just like some other people. He was implying that we assisted in that, which we didn't.
All right. I believe I have no further questions. Thank you very much.
All right, go ahead, counselor.
Where did this negotiation take place?
He's annoyed because
For
he's
the,
seen the
buyout of the
stupidity in
50,000.
this. I
The
can hear it in his
original
voice.
It was
He's
at
going,
our office.
where?
Well, that's wrong because it was in the car.
Objection, testifying, facts and evidence.
May I clarify, Your Honor?
Wait 1 second. I'm gonna sustain you were testifying there, counselor.
My apologies, Your Honor. So you say my client worked on multiple different places, but you only named Hex. Is that your testimony?
No, Your Honor. I can specify
Oh,
even
good
more if
Scrogs.
you want, as public records at.
That was my original objection for you to specify, but you never did.
Do you want me to say another company?
Yes, he was a dick,
I would
but
like to know the 5 that
fucking
you
hell,
said he
he's a
was
good
in.
lawyer.
He stated to me himself that he was he was an investor in 5 different companies.
Okay.
And easily, after he alleged that
Brother,
he
you
was
sound
fired
stupid.
and such. I've checked
You're not
multiple
helping
times
their
if it was
case.
on the public records at the
What would help your
office
case,
right
Kenji,
to the
now?
right of
Motion
us, and
to
he works for
strike
Sloan
his
Branch the entire
testimony.
time
Because he's a
after
fucking
he
idiot.
left the company.
Okay. So that's you're alleged that he works at a company, Sloan Branch.
Yeah,
I'm not alleged.
He mentioned as well that he's already mentioned that he's heard five different investments, and he gave one of the restaurants that he heard about. He also,
Yeah, Hex isn't a restaurant, by the way.
Up and coming. He
Up
has
and coming.
investments in that company.
All right. There's an objection. I'm gonna overrule the objection because I want the witness to answer these questions. Go ahead.
So what 5 companies does he work for that you stated on record that he has a job at?
He
I'm gonna-
stated
Go ahead, go ahead.
he stated to me himself that he is a part of 5. I don't
When
know
did he
all
state
5.
this?
Multiple different occasions.
Multiple
So
different. So
yes,
do you consider an investment a job?
See what I was saying?
if he has involvement on how the investment. Sorry, let me give me a moment. It would depend on if he has involvement in that business itself. You know, in managing the company or other different factors. I don't know that, you know.
So you really just don't know.
Objection,
In-
argumentative.
incorrect.
Your statement of facts.
Overruled. It's not argumentative at this point, Kenshi.
Incorrect.
Your Honor, I'm
That's
gonna
not what I
just
said.
motion you to strike anything about having a job due to
Uh,
he just doesn't actually know.
I'm gonna rebut to the fact that he did say that he himself checked on the data records publicly that he saw that he was employed since the quote unquote dismissal at Sloan Business. So it's not that he doesn't know. It's that at this point the witness
All right.
can't say what he doesn't know in terms of he was
You're
told
right.
he was
He can't say
invested
what
in
he doesn't
5.
know. So
All
this
right.
is why I'm
let me
asking
finish
to strike
with
this.
respect.
No, I don't need anyone to finish. At the moment, I'm denying in part. Again, Counselor, I'll take into account his
Okay.
full testimony and what he has said, and put appropriate weight to what has been said.
So you were present for the conversation with him and the head of DOJ. Do I recall that correctly?
I didn't say
Objection to
that.
the statement.
Okay, so you knew something about that involvement?
I'm confused about the question.
What was your sorry? I'll rephrase. What was your testimony to him calling the head of the DOJ?
Like it being discussed,
Yeah.
or I'm confused where you're asking. To be
Yeah, I'm
honest,
gonna
with you.
object. He didn't testify about anything about a call to the DOJ.
I could have swore, Your Honor, he testified to it.
All right. Luckily, I have notes, so I'm going to overrule. He did bring up the fact that a lot of this happened because of a call to the DOJ that he was made aware of in discussions. So answer the question.
Your Honor,
Uh,
I believe the wording he said was multiple different people. I don't think he said the DOJ.
I've overruled.
Could have
Kenshi,
sworn.
answer the question.
What was the question?
What did you know about the call to the DOJ that was being discussed?
He was so pretty much it was discussed throughout the company. Multiple of our the managers were involved in this discussion as it pertained to the company itself. So pretty much he alleged called the DOJ, alleged that the business had involvement in Chris's raffle, that more than us buying tickets, but alleging that we had involvement in it when we didn't.
So you're the company manager, correct?
I am a project manager with multiple other project managers. We have multiple project managers in our company.
Okay. I have to ask, being in that position, what does a raffle have anything to do with your company?
He was implying that we had assisted
Objection,
in people being
speculation.
scammed. There was possible charges already being done at the time that was of Chris. I guess it was being alleged that Chris's. Give me a minute. Let me formulate my sentence. There was at the time there was many articles and other things happening of whether or not Chris was going to be charged for possibly scamming in the raffle, and he pretty much was implying that we had involvement in that further than us our buying tickets. That was not the only occasion where his position was being in question. There was multiple different factors why his multiple different occasions his inability to act as a shareholder because of
So-
his issues and him telling other people about private stuff about the company in multiple different
What
occasions.
private stuff though? What private stuff is he
Objection. I
telling?
think he's now going into privilege, Your Honor. I think we just have
He's
to
on the
remind her that
stand, Your
this is
Honor.
understood, but this is a private business. If we're gonna air out the business's laundry and open court, that we're going into privilege now.
My client's an ownership, Your Honor. He has the right to know what he was, quote unquote, allegedly leaking to everybody.
I'm just gonna ask the court to consider the reputational damages that could be that could arise from this if privileged information is shared in open court.
Alright, I'm gonna overrule in part. I'll ask the witness that he answer the question, but leave out anything that could be deemed private information of the company. So he can answer it to an extent of business records or statements or X and Y, but he doesn't have to go into exact detail of what is in those records.
Okay. What was he leaking that you guys were so concerned about?
The amount of money we had in our balance, how our company was gaining the amount of employees we had at the time,
It is
Uh,
getting juicy.
our business practices of why we were being so successful compared to his friend at Plugged In.
So you're saying
His
he was sharing trade secrets to his friend at Plugged In? That's your
no,
accusation?
you're misstating what I said. I said why we are being much more successful than his friend at the time was.
Okay.
I'm not saying that he said it to her. I'm saying that he told multiple individuals why we were being more successful than his friend.
What individuals did he tell?
Uh, it, Moon Cafe people. There's like a whole list. He was really public about it, to be honest with you.
I don't see that anywhere written here. I don't see anything stating this. It's just your say
You're
of this.
the one asking for all this, respectfully.
I am.
Yeah,
Give me some
we didn't
names. Give
introduce
me,
this.
Your Honor, wise counselor. Is this an objection?
Yeah, counsel, is this an objection?
I'm gonna object to scope. We didn't introduce the fact that he spoke to multiple other businesses. We were focused on specifically the raffle. I don't know why we're going down this narrative of multiple businesses. We didn't even introduce that.
My rebuttal, Your Honor, is they brought into the fact that he was removed due to security reasons, and this gentleman just brought there was potential leaks from him. My client is who I refer to as him, Nathan Kookie.
Oh, this is annoying. I'm gonna sustain on that, though. It is going a bit out of scope at this point.
Okay. I'm just going to ask one more time. Where was the initial meeting that took place for the $50,000 buyout?
I'm just gonna object to ask and answered.
So just to clarify, you were stating it was in the office.
Do you
That's
want
all
me
I
to
wanted
answer?
to know.
Do you want me to answer, Judge?
1 second. I'm overruling. Answer the question.
There was multiple occasions where the 50,000 was mentioned before lawyers did get involved. The one I
And you
was
were
a part
present
of,
for it.
yes, I was present for one of them, it was the same 50,000 mentioned.
And where was that located?
The one I was a part of was at the office.
Okay. I have no further questions right now, Your Honor.
Thank you. Alright, you may step down. Unless counsel wants to redirect.
No redirect required, Your Honor. Thank you.
Alright. Any other witnesses, counsel?
No, Your Honor.
Thank you.
I
Evidence?
suppose we just like. Say again? Evidence. Yes. No. I think we just like to highlight the lack of evidence provided by the plaintiff in that no evidence was shown that he was unemployed from either ASS or any other uh, job
I'm not
at
even
the time
addressing that,
and had to quote unquote make
so
ends
it's
meet.
fine.
And yeah, I think we'll just go with the same evidence of the contract itself, Your Honor. Contract is
Ah.
very clear and unambiguous.
Thank you. That being said, both counselors ready for closing, or should I give you a brief reprieve?
Can you just give me 2 minutes, Your Honor?
All right, court's in recess for 5 minutes. Stretch your legs.
Thank you.
All right, ladies and gents, we're back in session. Counselor, you can go ahead with your closing.
All right, Your Honor.
My issue with that
this
whole...
case is not that complicated. Nathan Kookie invested $6,000 into Aqua Systems and Steels. In return, he received 150 shares, a 15% ownership, advisory stakeholder status, and the right to receive dividend proportional to the ownership. That agreement was signed by both parties. The defendant accepted Nathan's money. The defendant issued Nathan's the share. The defendant recognizes him as an individual with ownership rights. And yet today, the defendants ask the court to accept an extraordinary proportion that Nathan may own 15% of the company, but he has no right to know what that 15% is worth. That is not ownership. That is ownership in the name. The defense has attempted to describe Nathan as though he were a stronger standing outside the company demanding access to private information, but Nathan is not a stranger. He is not a competitor. He is not a member of the public. He is one of the owners. The defense says he is entitled only to public information, but there is no public available information. Nothing meaningful was submitted, nothing was disclosed, nothing exists outside the records that remain entirely within the defendant's control. So the defense position, circular by design, the records are private because they were never made public, and because they are private, Nathan cannot see them. The argument would allow the controlling shareholder to place every relevant financial record behind a locked door, declare a value from the other side of that door, and demand that the minority owner either accept the price or walk away blind, Your Honor, as you know, Kenshi is, or I guess the old Kenshi.
Whoa!
Equity cannot permit that. The court has heard the defendant initially offered approximately $50,000 for Nathan's ownership. Nathan did not reject that offer out of greed. He did not demand an unreasonable premium. He did what any responsible owner would do, surrendering 15% of an ownership. He asked for the figure had to be calculated. He requested the books for an independent, and instead of receiving transparency, he received exclusion. Instead of explanation, he received a new offer of approximately $10,000 in bad faith because he wanted to get legal
No, but you
right.
can request Penny for evaluation of your shares for
The
buyout.
defendant explanation was the company had
And while
spent
they don't have
substantial
to give that
money
to you,
upgrading its operations.
they can
Perhaps
give that to an
perhaps those
independent
expenditures were
financial
legitimate,
evaluator
necessary, and
to
made
determine the
entirely in
values of your
company's
shares
best interest. But the
and
defendant
you
was
being able
withheld
to
the
be bought
very
out.
records that would allow Nathan and this court to determine whether the explanation is true. And the expenditures were proper, the books will show it. In the company's value genuinely declined, the books will show it. In the original offer was mistaken, the books will show it. If the later offer was fair, the books will show it. The defendant cannot rely upon financial activity in the justification for reducing Nathan's buyout while simultaneously hiding the evidence of financial activity.
Are
The
you
written
asking if they
agreement
can be
also
bought out
entitles
once the
Nathan to
offers? Can they be
dividend
forced to
proportional his
buy out
ownership. That right
once the
means
offer is
nothing if the
made?
defendant alone decides that the company is earned, what it spent, what the profits remained, and whether any dividends was owed. Without an accounting, the promise of proportional dividends becomes nothing more than a trust us, bro. Again, Your Honor, at the end of the day, they can show us the books. We can determine what the dividends is going to be. It can be under scrutiny. It can be under lock and key. If they just show the lawyers who have a fiduciary obligation to our clients and exclusion, then yeah, we can determine what it's worth and what the dividends is or what the buyout could be. At this time, we have not been given any of that. So, respectfully, Your Honor, we request that some kind of ruling be made here today that, protects people that invest in companies that are getting screwed because the owner decides, nah, I'm not going to honor that. It was a shitty written fucking contract, and here we are. Thank you, Your Honor.
Thank you. Defense counsel.
Thank you, Your Honor. Over the course of these proceedings, the evidence and statements provided by witnesses has made one thing abundantly clear. The plaintiff has failed to establish any legal basis for the relief that he seeks. The shareholder agreement, or the contract that was presented to the court, is clear and unambiguous. The legislation as well is clear and unambiguous. Mr. Kookie is a minority stakeholder owner. He's not while the word owner is in there, he's not technically an owner of the company. He owns stakes within the company or shares within the company. It defines the plaintiff's rights as a shareholder, and it does not anywhere impose an obligation upon the defendant to obtain or provide a fair market valuation of the plaintiff's shares. With respect to the court, we cannot expect to rewrite a contract simply because one party is dissatisfied with the bargain they voluntarily entered into. The plaintiff has attempted to portray the dispute as one of fairness. However, fairness cannot override that express terms of a binding agreement. More importantly, the evidence that we provided demonstrates that the defendant nevertheless made a reasonable and generous offer to purchase the plaintiff's shares despite having no contractual obligation to do so. The plaintiff had access to the books at the time of this offer. He could see what the value of his shares were. He rejected the offer, not because it was objectively unfair, but because his goal was never to simply sell his shares. He mentioned that he did not care about the money. All the while, as I mentioned, he had access to the full books at the time. The claim was that he asked for the books for an independent valuation, but as I said, he had access to the books. The plaintiff claims bad faith, but the bad faith here is that the plaintiff was given a fair valuation that he himself could verify, but chose to refuse and again say that it wasn't about the money. The evidence instead supports the conclusion that this litigation was pursued to burden the defendant, damage her company's reputation, and gain access to information to which the plaintiff was not otherwise entitled. Your Honor, litigation is a mechanism for resolving genuine disputes and not a tool for harassment, leverage, or commercial sabotage. Throughout these proceedings, the defendant has acted in accordance with both her contractual obligations and the law. The plaintiff, by contrast, has asked the court to create contractual rights that simply do not exist. For this reason, we respectfully ask the court dismiss the plaintiff's claims in their entirety. We further request the court award the defendant her legal costs in the amount of Actually, you know what? I'm not going to say that because that would be a countersuit, and I haven't filed that yet. So we'll just request that the court dismiss the plaintiff's claims in their entirety. And we also ask the court to remember that Mr. Kookie had access to the books, and he said that it wasn't about the money. And then he decided to pursue civil litigation with some form of obsession with Aqua and her company. That is all, Your Honor. Thank you.
Your Honor, can I just got notification that Mercy Schilling's awake, and it could be a rebuttal witness to a lot of these allegations. Would I be?
Well,
able to
we've
call
already
this in?
moved. We've already moved
I
into closing
mean,
counsel.
I get that, but this could be, something that you might be interested in.
With all due respect, Your Honor, I mean,
It's just a rebuttal witness.
we've
No,
all gone-
I would gladly entertain that conversation after the case, but we've already moved to closing at this time.
Thank you, Your Honor.
I'm not going to allow any additional witnesses in.
Okay, Your Honor. It's just, was there a testimony out of rebuttal? That's all.
Understood. Right, I'll be in chambers deliberating. I can't give you a promise on time, but I'll make it clear when I'm out and then get everyone present. Court's in recess for the moment.
Thank you, Your Honor.
Ball. Alright. I'm back. Apologies for the long wait, ladies and gentlemen. As you might know, this is not a simple case, and the first of its kind in Los Santos at the moment. Alright. First, as a prelude to this ruling, the courts address the management risks. Plaintiff Nathan Kookie holds 150 shares, 50% equity, with advisory status under the founding agreement as per the contract provided to the courts. Advisory status does not grant operational control, board veto power, or open book inspection rights to corporate trade secrets. CEO Asuka retains 100% operational command, and all claims seeking direct business oversight are dismissed. While the plaintiff, Mr. Kookie, in this case, has expressed in court that he wished to work with the company and retain his shares, the courts will not force an oppressed partner to remain trapped inside a hostile enterprise, nor will we subject a private business to ongoing court-supervised accounting. To prevent permanent corporate deadlock, the courts exercise its broad equitable discretion under request number 5 to order a mandatory severance and binding buyout at the company's initial baseline valuation of $51,000. I will now address each request as listed in the docket. On request 1 for ownership, plaintiff is confirmed as the 15% owner, but those shares will be surrendered and cancelled upon final payment today. On request 2, 3, and 6, they will be denied as moot. The court will not compel trade secret or financial disclosure. Instead, we adopt the defendant's initial stipulated offer of $51,000 as the unmanipulated fair valuation for the stock and withheld dividends. On request 4, the injunctive relief, the injunction was already granted, but now the temporary injunction will be lifted upon payment of the amounts listed today. On request 5, the equitable relief, that will be granted. An immediate mandatory buyout is ordered. Finally, defendants Acquaviva Systems and Steel and CEO Asuka are ordered to pay plaintiff Nathan Kookie $51,000 within 48 hours. Upon receipt of the funds, I did not ask you to step in, Counselor.
I just wanted to clarify, Your Honor.
I don't give a shit. Upon receipt of funds, plaintiff's 150 shares will be surrendered and cancelled, completely severing all corporate ties. That is the ruling of the court today, and this case is closed. Court is adjourned.
Your Honor, the original agreement was 50,000, not 51. That was a clerical error on the behalf of the plaintiff.
Ah, alright.
That's what I was trying to explain. I wasn't going to argue with your ruling. That's
Yeah,
all I was
just
trying to explain.
let me finish in the future, Kenshi.
Yes, sir. Apologies.